No, he didn't.
I didn't say anything.
All right. Fortunately, just report from County of Washington, I'll say that we now back in session, the honorable judge, Jason.
You may be seated.
As the final plea echoes through the room, one thing's clear. Justice isn't always loud. Sometimes it ends in a whisper.
People versus Kyle Humphreys. And from the other side, crickets. This is Ron Brown's case. Yes. Why did I pass?
Brown came on the application. He's appearing by Zoom.
Is he on there?
Mr. Humphreys, we tried. He's in treatment. Your Honor, we're requesting an adjournment. He's in treatment.
Oh, but I don't. Do I have anything that indicates he's in treatment other than you?
Well, we sent over a Zoom request because he was in treatment, so that kind of backs up what I said, because you allowed him to appear on Zoom, right?
It does.
Because that was your decision.
What was my decision?
To allow him to appear on Zoom, because he was in treatment.
He's got the good shit.
Okay, it was represented to us that he's in treatment. So you can appear via Zoom. Do I know if he's in treatment? I ain't been there, so I don't know.
I've been in court almost.
Bench warrant will issue. 10,000 cash surety in each case. What I will do, Mr. Brown, is I will not issue his bench warrant until August 4th, 2025, Monday. If you can get proof to the court that that's where he is, then we'll reset him.
Thank you.
Thank you. It's kind of, if you want enough, maybe you get what you want. No, nothing. Go ahead. No, we're good.
Recall, he's here now.
Court calls the case People versus Alvin Jones.
Student Attorney Kara Rosen on behalf of Mr. Jones, who should be appearing by Zoom.
Mr. Jones, can you state your name, please? Okay. Yeah, I see your lips moving. You need to unmute.
Might be muted.
Okay, there you go. Can you state your name?
Alvin Jones.
All right.
Thank you, Mr. Jones. I just want to put on the record, to Your Honor, that it was 100% my fault that Mr. Jones didn't appear earlier. So he had the wrong passcode, and that was on me. So to get into the meeting. So I just wanted to take responsibility for that. And we're going to be asking.
I kind of knew that.
Yeah, I figured, but I just wanted that on the record, Your Honor. And we are requesting.
Now everybody else knows.
That's okay.
I was just going to let it.
I like to own up to my mistakes, Your Honor.
Don't do that. You won't make a good lawyer.
So we are requesting an adjournment. To my knowledge, we're just waiting for some video discovery to be uploaded into DD so that we can review it.
August 14th, 2025, 9 a.m. Bond continue.
All right. Thank you so much, Your Honor.
Thank you. And
Thank you, Your Honor.
And the other thing that counsel you did is when I was debating whether to issue the bench warrant, you just kind of looked up and said, please. So that helps.
Puppy dog guys. Thank you, Your Honor.
You're welcome. Court calls the case, People versus Bruce Dinkins.
For the people.
Ken Madadish on behalf of Mr. Dinkins, who is approaching.
There we go. Okay.
Let's try this again.
Your name, sir?
Bruce Dinkins.
Okay, I think we were at the point of the factual basis for the plea.
Your Honor, may I voir dire again?
Go for it.
Mr. Dinkins, were you given a tether by the probation department?
Yes,
And when you received the tether, you were instructed that the tether must remain charged at all times, correct?
yes,
And you were told that if it was not charged, the probation department would not be able to get the transmitted data from the tether, correct?
yes,
And you allowed the tether to run out of charge. You knew it did not have charge, and you did not recharge the battery, correct?
yes,
And you knew that while the tether did not have charge, the probation was not receiving the data,
yes,
and you did not have authority to do that, right?
yes.
Okay, still don't see a larceny by conversions.
Well, higher charge is the tampering. Your Honor, we were trying to establish a factual basis for the higher charge, the tampering with it.
Is it failure to charge it tampering?
It's circumventing
What?
the purpose of the tether by not charging it. Should I try the other one? Until July 9th, 2024, which was more than a year after you absconded, correct?
Yes.
Your Honor,
Yeah.
let me offer this on behalf of the people. If the attempt is to do that, then
If what?
if the attempt is to matter of Mr. Dinkins not keeping a charge, that would fall under the next.
How long did he not keep a charge?
Mr. Douche?
He received it 10 days later. They stopped receiving any
What?
So he got the tether around 10 days after he got the tether. They stopped receiving. So that's when he had stopped charging.
Okay, so he stopped charging, it's 10 days, and then when did they catch up to him or do whatever?
1 year.
Ow. Now I see, maybe you should have led with that.
Yeah.
So that would qualify for the larceny by conversion that I think we've been trying to get. He just got returned for 1 year.
I'll take the larceny by conversion and take the absconding as a higher charge and have him plead to that, but I don't know that that's even larceny by conversion. They got their tether back.
Yeah, actually.
Two sides, one truth, and a courtroom slowly turning into a battlefield of emotions and evidence.
Are we good?
That's a relative word. All right. Sir, you understand that if I accept your plea to this lower charge, that if you do commit misconduct between the time of my acceptance of this plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you would not be entitled to withdraw your plea, and any sentence agreement or evaluation, the court would no longer be bound by. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
None known by the people, Your Honor.
All right. And have I complied with the court rule?
Yes, Your Honor.
Defense is so satisfied, Your Honor.
Okay. The court will accept the defendant's plea to count two, accepting the higher charge. Pre-sentence investigation and report is ordered at 14A1 probation. Great. Sentencing in this matter will be
August 27th at 12 noon.
August 27, 2025, 12 noon. Bond will continue.
Your Honor.
Court calls case People versus Paris Lester.
Your Honor, can I judge on behalf of Mr. Lester?
Okay, Your Honor. It is my understanding that Mr. Lester, well, first of all, I haven't had a chance to speak with him about this because he was at treatment. Miss Lauren Pereni did arraign him, but she did not get a chance to speak with him before to understand the circumstances behind the alleged violation, or therefore we are going to be asking not to address the violation today. We were going to be asking for an adjournment. From my understanding, he was trespassed from 1200 Broadway and on 1 mile radius outside of that. And I believe the U of M hospital is outside of that radius. Anyway, we did try to understand what happened at the treatment center, but we don't have that yet. He is at the hospital, admitted to the hospital as a patient.
But is he still there?
Yes, as of an hour ago, he was there. I can call and ask if he's there right now, but he was admitted for medical help.
Do you have any objection if I adjourn this?
Your Honor,
You do.
based on, I don't. I was gonna give a long yes.
Oh, okay.
Your Honor, he is still on the GPS tether, I believe. If he leaves the hospital, there would be a way to track him.
Why is she, I don't know why you're still talking.
I'll just
I was
stop
gonna
talking.
give you an adjournment.
Thank you.
All right. Probable cause conference, August 14th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case of Anthony Hamilton, People versus Anthony Hamilton. Just had to record the,
Good afternoon, Your Honor. Robert Agasinski for the prosecution.
Good afternoon, Judge. You and your staff, Robert Burton Harris, on behalf of Mr. Hamilton, who's also present.
Your name, sir?
Anthony Hamilton.
All right. And what are we doing, Joe?
Judge, we're asking this matter to be scheduled for preliminary examination. I spoke with your staff.
I know. They didn't like it. No, I'm kidding.
Well, I was going to say, I spoke to your staff and they believe that the 19th is available.
Yeah, they told me.
And I think that date is.
Will that work for the people?
Yes, Your Honor.
All right. All discovery is complete.
Yes, Judge, as far as I know.
Preliminary examination in person will be set for August 19th, 2025. And that is going to be at 12 noon on that date, and that's before me. So it doesn't start till the afternoon.
And Judge, just for completeness of the record, I think Brother Counsel has 4 witnesses.
I expect 4 witnesses for that exam.
Lengthy witnesses. I'll tell you what the only thing about putting it on that date is it is another split date for me where I have PCCs in the morning and then exams in the afternoon. And I can't tell at this point how many exams are going to be set on that date. So.
I wouldn't be surprised if it took 2 hours.
Oh. Okay.
I would be surprised if it took 2 hours.
You would be surprised?
I think so.
Okay.
Do you think it's going to take longer?
No, I think 2 hours should be sufficient, especially if me and Brother Counsel are going to agree on some.
Well, we'll put it there and we'll try to get you guys in on that date because I just can't tell what it entirely looks like, but we'll get you done. All right. Bond will continue.
Thank you, Judge.
Court does call the case, People versus Jamie Foxx.
On both cases. Michael Gaddy, Assistant Public Defender on 25F20223, Your Honor, and standing in for Mr. Friedman on 24F21502 with Ms. Fox's permission.
Is that correct, ma'am?
Yes.
All right, very good. And what are we doing on this?
Your Honor, may we approach briefly?
Can I stop you? No, come on.
And just when you think it's over, the victim reappears in the story. Against all orders, against all logic. This just became personal.
Thank you for the bench conference, Your Honor. I am asking for a 3-week adjournment in this matter so we can locate and review some medical records.
Well, and my understanding is now the medical records, have they been located and then provided?
Well, that depends, Judge. I believe the prosecutor says that we picked them up on July 18th. We say we don't have them, so I sent someone back over to the prosecutor's office this afternoon again.
Right, and I'm just saying, let's move this ahead. So if they're as we sit here right now, do you have them does the PD have them in their possession?
I don't believe so, Your Honor. But the prosecutor's office has told us that we do. But I am endeavoring to locate them and review them.
Got that. Okay. So I just don't want to get here on the 19th and then I go through the same thing.
Yeah.
So what I'm going to order is I'll adjourn it out to the 19th, but if by Monday, the PD doesn't have them, then that redacted copy, there needs to be another copy presented. And if people got to go down there and witness the exchange of it, then they need to go down and do that.
Thank you, Your Honor.
Your Honor, I'll just say, I have no problem at all, of course, getting another copy from the public defender's office. I just want to say on the record that we've had those documents available on DVD for public defender's office since June 26th. But I have no objection to the adjournment, and I was even going to suggest that if they don't have them for whatever reason, I'll make sure we get another copy.
Okay, I'm going to hold the attorneys responsible to make sure that those documents get there. I wasn't there. I don't know who's got what, and I can't stay. All I know is that it needs to be exchanged. I have no reason to disbelieve either side in terms of we gave it to you, or the public defender says we don't have it. I don't have any reason. It just needs to get done. August 19th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Judge.
Get all my stuff and earphones in here. Double files. Court does call the case of the people versus Christian Ramirez Fernandez.
The stalking behavior also has additional factors of telling the victim he was going to rape her in front of their child, and he was going to threaten her throat. I could go on and on. I don't think it's necessary. It's extremely constraining behavior. And the fact that he then decided to violate his bond very quickly after being informed of those bond conditions is just adding to our concern for victim safety, for community safety. So we'd ask for your amendment.
Just wanted to see my daughter.
Anything else, Mr. Brown?
No, Your Honor.
The court has reviewed, at least preliminarily, the Monroe Police report and looked at it, and having heard the arguments in this case, let me just very simply put that this is a stalking case, and then there is stalking behavior, which is clearly delineated, continuing against this same victim. So I've set it for the 14th. At this point, given what the court has seen and pending the hearing, defendant's bond is revoked, defendant's remand. Court does call the case People versus Kevin Riggs.
Andrew Bannon.
Ashley Bashir for Kevin Riggs, who's approaching.
Kevin Riggs.
Thank you, sir.
In Your Honor, I have a green sheet. We're requesting a 3-week adjournment if possible. The prosecution has notified us of a newly authorized matter that we'd like to track with this one.
Okay, when has it been sworn out and has he been arraigned? I mean,
Your Honor, I authorized the charge yesterday. It's being processed. I still need to sign it, swear to, and an arraignment. I assume I'll be able to sign it today or tomorrow.
what I'll do, counsel, is I'll put this on the 19th, okay? 2025 at 9. If it doesn't get through, I'm not gonna have a problem pushing it out to the 28th. Let them all try to catch up.
Thank you, Your Honor.
We'll work with you to try to get that done.
Thank you, Your Honor.
You're welcome. Take care. Court calls case People versus Alexa Rushing.
Okay, I'm here.
Michael Gaddy, Assistant Public Defender on behalf of Ms. Rushing, Your Honor. She is present by Zoom.
Okay. All right, what are we doing?
Your Honor, I'd ask the court for a brief adjournment. Ms. Douglas and I have had some discussions about settlement. I think we're very close.
We'll adjourn the probable cause conference. August 14th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you.
That's an in custody. Court recalls case People versus Christian Ramirez Fernandez.
When the judge lowers bond, it's not mercy, it's strategy. A small move that speaks volumes about what's coming next.
Good afternoon.
Good afternoon to this honorable court. Attorney Carla Marable on behalf of my client. Please state your full name for the record, sir.
Christian Josué Ramirez Fernandez.
All right, what are we doing?
Yeah, I do have discovery, and I would like to set it for a preliminary exam, and I also need to address the issue of bond.
Address an issue of bond? All right.
Yes, Your Honor, my client, he owns a construction company, and he needs to travel out of the state on August the 2nd, and I have all of the information for the court to pick up some equipment. It's just a one-day trip to Pennsylvania to pick up some equipment, and he will be coming back.
Have you reached out to the prosecutor's office regarding a stipulation to that travel?
You know what? He just recently told me about that, and no, I did not. Because I knew he was in court.
If you get it to the prosecutor's office, get the information that you have provided to the court, see if you can reach a stipulation. If you can't, then send the information to the court and I'll address it. But if the parties can stipulate to his travel for one day, I don't foresee that being a real problem.
Well, can we do it now on the record?
Can you do what?
Can the prosecutor now stick to the, him traveling? It's just for one day.
How are they going to do that any more than I can when I don't have any of the information?
Okay, thank you, Your Honor.
And defense counsel to look at it.
You put your email in the chat.
Yes, ma'am.
Okay, thank you.
Any other demands you want?
Well, there's a lot that I want, Your Honor.
Well,
no. Well, I get it.
No, I'm getting very good at saying no. So I'll let you keep listening.
Okay.
All right.
We do have discovery, and we're just asking for a preliminary exam date, Your Honor.
People have their witnesses. Preliminary examination in person will be set for August 12th, 2025, 9 a.m. That will be before Judge Freshour.
Thank you, Your Honor.
Thank you.
Thank you.
And I will send the slip over to the prosecutor office.
Thank you.
Thank you.
Thank you.
Court calls.
Good afternoon, Your Honor. Ray Douglas, the prosecuting attorney on behalf of the people.
Good afternoon, Your Honor. Particularly on behalf of Ms. Mayor. Also, as you say, Judge, I was appointed 2 hours ago. This is what I understand the situation.
She did.
She did. It was for 2 days.
We tracked her all the way to Tennessee. Go ahead.
For 2 days, when she found out that what she did was against a court order, she turned herself in. There have been no violations as to the tether or her contacting the victim in this matter. It's my understanding she has no vehicle. She has made no contacts with the victim. And what we're asking for is for you to release her, hopefully without a tether. She lives in St. Clair Shores. He lives in Whitmore Lake. If anything, he's contacting her, and she knows she cannot speak to him. So what we're doing is we're asking to adjourn this PCC 3 weeks. I'm asking her to be released on jail on a PR bond without a tether.
Response from the people.
Thank you, Your Honor. Your Honor, no objection to adjourning the matter as far as the bond matter. I'm going to leave that to the court's decision. I don't have any reason to believe there's been a violation of lawful contact, and I'll rely on counsel's representation that perhaps not been.
All right. We'll adjourn this matter to August 19th, 2025 at 9 a.m. Ma'am, why'd you leave the state?
It was my family reunion and my oldest aunt is like passing away. So my entire family was going down there. It was planned for like the last 6 months. And I honestly just thought I couldn't go to Dustin's house. I didn't know I couldn't do anything. I've never been on tether or in trouble before.
I'm going to believe you because we saw you going all around everywhere while you were in Tennessee, and there would have been no reason to try to leave the state. I mean, it was clear to me you weren't trying to abscond. And I believe, I don't know how you missed it, but I believe you that for whatever reason, you weren't thinking that you couldn't leave the state of Michigan. So I'm going to reinstate your bond back to a personal recognizance. I'm going to release you with the same conditions. Do you understand that?
It means no contact. The same conditions.
Same conditions that you had before you decided to take off south. All right?
Do I still have the tether?
She's asking me does she still have the tether.
Oh, yes. Because if you didn't have the tether, we wouldn't have known that you left the state. Right? So I believe that you did what you did, that you weren't intending to try to do everything, but I still see a necessity for the tether. So I'm going to leave the tether on. All right? And certainly then we can deal with it at the 19th or whenever this case begins to resolve. All right?
Thank you.
Place their personal recognizance 5,000 she had before with the conditions. And we'll see you on the 19th.
Okay, you're going to get out when you get out. Give me a call. Okay.
Court calls case People versus Michael Ware.
Victoria Burton here, Super Assistant Prosecutor of Area on behalf of people.
Edward Drukas on behalf of Michael Ware.
Look at the defense attorney's face. Calm outside, chaos inside. They're trying to save what's left before the verdict hits.
You're waiving your right to a preliminary examination, sir?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on a single count. Mr. Drucker.
We will acknowledge receipt of the information, stand mute to the charge, and ask for a pretrial date.
Defendant having waived from reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
September 23rd at 1:30 with Judge Cumpy.
September 23rd, 2025, 1:30, Judge Cumpy.
Thank you.
Thank you.
Continue. Oh. Sign off on the information. Court does call the case of the People versus Dwight Williams.
Andrew Bannish for the people.
Mr. Kilowald's case. Are you Mr. Williams? Come on up.
Sorry, Judge.
Take your hand out of your pocket.
Good afternoon, Judge. Robert Jacob on behalf of Mr. Williams. Judge,
Your name?
Dwight Williams. Judge, I was just appointed on this matter. Can we get the August 19th date again, Your Honor, please?
Probable cause conference, August 19, 2025, 9 a.m. without objection, bond continues.
Thanks, Judge. Appreciate it. Thank you.
Court calls the case of the people versus, is it Uni Singletary?
Victoria Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
The attorneys.
Officer Bashir, on behalf of
Rob Robert Green on behalf of the
Ms. Singletary, can you unmute? Thank you.
Singletary.
Thank you.
You're welcome.
We're requesting adjournment for additional discovery.
What's
I have to go through the file to remember because I have so many.
probable cause conference will be adjourned August 14, 2025, 9 a.m. bond continued.
Thank you.
Thank you, ma'am.
Thank you.
Court calls case people versus Delaney Smith.
Thank you, Richmond.
What?
Stephanie Cannon on behalf of Ms. Smith, who is appearing to my right. Ms. Smith, could you please state your name for the record? My name is Leilani Smith. I'm asking for adjournment in this matter. I'm trying to call. I have.
Everybody remembers when you get it wrong.
Okay, I remember this coming. So which one?
Probable cause conference August 14, 2025, 9 a.m. Bond continued.
Thank you so much, Your Honor.
Court calls case people versus Kirby Snyder. Kirby Snyder.
Michael Gaddy, Assistant Public Defender from the Snyder Unit. Your Honor, I've called in the courtroom, I've called in the hallway, I haven't seen Miss Snyder. She did contact my office this morning and said she was at urgent care, and then she contacted her a while ago and said she was on her way. I don't have any explanation as to where she is, so I'd ask for a show cause.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue.
Thank you, Your Honor.
Case of the people versus Devon Sykes.
Herman Dadush on behalf of Mr. Sykes, who's appearing by Zoom. Mr. Sykes, can you please state your name for the record?
Devon Sykes.
Your Honor, we have come to a resolution with the prosecutor's office. However, we are going to be asking for an adjournment for Mr. Sykes to come up with restitution so he's able to take advantage of the offer.
Okay, so how much time is he going to need to do that?
So the agreement is, hopefully we can adjourn it out a month and he'll have it all paid by then.
You think you can do it within a month?
Yes, no problem.
Probable cause conference August 28, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Let's call the case of the people versus Leo Taylor Jefferson.
Burton Harris, Chief Assistant Prosecutor, appearing on behalf of the people.
And Assistant Public Defender Chinazi Carey-Akinruli on behalf of Mr. Khalil Taylor Jefferson. Khalil, can you turn your camera on, unmute, and state your name for the record, please? He's on Zoom, Judge. Your name, Khalil?
Khalil Taylor Jefferson.
Thank you. Your Honor,
Khalil
the
Taylor
court,
Jefferson.
Your Honor, the court should be in receipt of a referral to the sobriety court. we'd like to ask for an adjournment and yes, sign that so we can see if Mr. Taylor Jefferson is eligible to enter the treatment court.
And this morning. All right, I've signed that. And how much time are?
I know,
All right, here's what I'll do. I'll adjourn it out to the 19th.
Okay.
Let's just see where we are.
that's fair, Your Honor. Thank you.
Bond will continue.
Thank you, Your Honor.
Case of the People versus Darnell Taylor.
Good afternoon, I'm Retail Assistant Prosecuting Attorney on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Taylor, who's approaching now. Please state your name for the record.
Darnell Taylor. All right.
You're under arrest and that this matter be set for a preliminary exam.
All discovery is complete.
Yes, to our knowledge.
People have their witnesses available to 12. Preliminary examination in person will be set August 12th, 2025, 9 a.m. That is before Judge Valvo. Bond continued.
Thank you.
Thank you, Judge.
Thank you.
Court calls case People versus Shaquise Tillison.
If you're Richard McDuff for the people.
Ron Brown, on behalf.
You get my green paper?
I did not.
Jacquees Tillison.